And so once again, just welcoming everyone. We're so excited to have you here today. My name is Amy. I use her, and we're so excited to have Clara McGregor from ACE to speak to us today on power of attorneys for caregivers. Before we dive in, I want to acknowledge that while we're virtual, I am joining you from the traditional lands of the Huron-Wendat, the Seneca, the Haudenosaunee, and most recently, the Mississauga of the Credit River, and that this land is covered by Treaty 13. And so our fabulous host today, Clara, once again from ACE, has been a ACE staff lawyer since 2016. She spends her time providing legal advice and representation to low-income older adults. She enjoys public speaking and speaking to diverse audiences about many legal issues, including housing rights, elder abuse, public pensions, and substitute decision makers. She trains and supervises a rotating team of students and contributes her experience to various committees and projects, which focus on the rights of low-income older adults. She's keenly interested in practical problem solving, peaceful conflict resolution, and access to justice. And she's also a graduate of Queen's University Faculty of Law. And so once again, Clara, thank you so much for sharing your time today, and I'm now happy to hand things over to you.
Thank you, Amy. Thank you for that warm introduction. Can you hear me all right? Can I get a nod, Amy? Okay, great. I'm going to share my screen. How does that look? Can you see?
That looks great.
Okay, wonderful. Let me see here. I'm just going to do a little bit of a tinker on my end. Okay, great. Thank you so much, everybody. I'm so glad that you're here today, and I'm so grateful to have been invited. I really love talking about substitute decision-making and powers of attorney, because in my job as a lawyer, I often see things after they've gone haywire. And anytime that I can participate in public legal education to try to help people understand their legal rights and the legal rights of the people around them who they love and care for, I think that we're doing really, really great work. So you often hear the expression that an ounce of prevention is worth a pound of cure. And I hope that that's what we're doing today, empowering you, and then perhaps you sharing that knowledge with those around you so that you can understand your own legal rights and the legal rights of those people that you love. So I think I'm just going to jump right in. As Amy said, there will be a section at the end for questions. It's always fun if I get stumped. It's possible you might ask me a question that I don't know the answer to off the top of my head. And I think that that's okay. If that happens, I will endeavor to do my research after the presentation and send you a great answer at that time. Okay, so as Amy mentioned, I am a lawyer at the Advocacy Center for the Elderly. You may be able to tell from my background that I am actually coming to you live from my living room because our entire office has continued to work remotely during the pandemic for various reasons. It's been a big transition to move to a remote model, but on we go. It's a great privilege, I know, in a lot of ways for me to be able to work from home. There's been a lot of people who want to do that in the pandemic who can't. And so I have gratitude. I also miss working with my clients and colleagues in person. So if we were in the pre-pandemic times, I probably would have hopped out over to Scarborough and met with you all together in a room, and that would have been really fun, but here we are. So when I'm not working from my own home, you would find me at 2 Carleton Street, which is right by College subway station in Toronto. We're on the 7th floor of that building, and it's usually a very busy office with people coming and going every day. We've got our contact information here, and our telephones still are being answered live, though because we're a really busy office, sometimes you have to leave a message. But I will be sharing this PowerPoint presentation afterwards, so you don't have to worry about writing down all of these phone numbers and website addresses, because you can look it up after the fact. We are a legal clinic made up of 6 lawyers. I'm one of 6, and one of our 6 lawyers is our executive director who manages the clinic. We also have 3 licensed paralegals and an office administrator. So we're a team of 10 right now. We sometimes have students who volunteer with our office or who work with our office. And we're hoping to add on more support staff early in the new year, so fingers crossed. As a legal clinic, we are actually, I should have mentioned this right off the top, our catchment area is the entire province of Ontario. So that's one of the reasons that we're so busy. The legal clinic system in Ontario is divided up into 2 main kinds of legal clinics. So we're funded through the provincial government, through the Ministry of the Attorney General. And we have, there's about 74, I think, legal clinics in all of Ontario. Every geographic area, so no matter what town you live in the province, you have what's known as a local community clinic that helps you within your geographic confines of whatever your area is. There's also what are known as specialty clinics. The Advocacy Center for the Elderly is a specialty clinic because we work in areas of law that serve a particular demographic. So our work targets issues that are of special interest to lower income older people in the province. So that looks like lots of work around long-term care homes and retirement homes, substitute decision-making, which is the focus of our conversation today, financial abuse and other forms of elder abuse that can come up, housing rights for older adults. Those are our primary areas. Some consumer protection matters, particularly around door-to-door sales. Okay, so because I'm a lawyer, I always start with a disclaimer. This is general legal information that I'm presenting for you today. That means that I don't want anybody to take any of the information that I'm providing today as legal advice to be applied to a particular situation. So even if we're talking about something that sounds very familiar to a situation that you find yourself in, I'm not giving you legal advice. It's always important to make sure that you seek your own legal advice for your own circumstances because every situation is unique. Okay, so I understand that most of you are here because you are caregivers, and I know that caregiving can take a lot of different forms. And so I think the information that we're talking about today is very useful for you in your role as caregivers. It also may be very useful for you in planning for your own life as you get older or as other people around you are aging. So all this to say, I think powers of attorney are an important topic for everybody, and I'm really glad you're here. So it may be that some of you who have joined us today have been appointed as an attorney by somebody who loves you. So you may hold a document that says that you are the attorney for property or personal care for somebody. And you might be wondering, what does that actually mean? That's a really good question. And I was telling Amy before we got started today that I went all the way through law school and then worked as a lawyer in private practice and then came to the Advocacy Center for the Elderly before I really knew what a power of attorney document was. So if you are scratching your head about what a power of attorney is, you're certainly not alone. And I'm really glad that you're interested in learning more. So we're going to start by very broadly talking about different kinds of decision-making from a legal perspective. So how does the law understand the mental capacity to make decisions and how we can plan for the possible incapacity of somebody who's no longer able to make their own decisions? And as you'll see, decision-making is divided at law into 2 main categories. And I've already referenced this a little bit. There is decision-making for property and decision-making for personal care decisions. And I'll break down what each of those means. So we're going to start by talking about decision-making and capacity generally. Then I'm going to take some time to talk about property decision-making first. Then we'll move on and talk about personal care decision-making. And I can show you just for a little bit of reference, I have this book that often sits on my desk. It's very heavy. It's called A Guide to Consent and Capacity Law in Ontario. And look how thick this thing is. This is a big, thick, complicated book. And it's got reference to a few different important Ontario laws in it. One called the Healthcare Consent Act that I'm going to talk to you a little bit about, and one called the Substitute Decisions Act that we're going to reference today as well. But I just want to give you a sense that this can get really tricky. The nitty-gritty of capacity law is sometimes really hard. And we will sometimes have debates at my office about how certain things get pieced together or what needs to be done in a certain situation. So I certainly don't expect anybody to walk away today feeling like an expert in powers of attorney. But what I'm trying to do is just give you some working knowledge so you can understand as a caregiver or just for yourself how you might encounter powers of attorney in your own life. Okay, and as Amy said, there'll be a section at the end for questions. And then the last slide is a list of 4 or 5 resources that can really helpfully summarize a lot of the information that I'm talking about today and would really encourage you to take a look at afterwards. Okay, so what kinds of decisions do we make in our life? Maybe that sounds like a funny question. But as I mentioned, the law divides decision-making into 2 main categories. There's property decisions and personal care decisions. So what are property decisions? Those are all the decisions about money, real estate, so that might be your own house or other commercial real estate or residential real estate you might own, personal goods like your stuff, the furniture that's in your home, investment accounts, bank accounts, pensions, Social Security income like Ontario Works or ODSP or the Canada Pension Plan Disability Program. Those are all examples of property under the Substitute Decision Act, and they fall into the category of property making decisions. So anytime a decision needs to be made about any of those things, that would fall into the property category. Then we have decisions about personal care. So that is shelter, nutrition, hygiene, safety, what you wear, healthcare. So you can probably already see that there's places where these 2 types of decision-making can overlap. Because if we're talking about decision-making around real estate, which falls under the property category, and decision-making around shelter, which falls under the personal care category, I can certainly see where those things might come together, and there might be a need for coordination of different kinds of decision-making, which, as you will see, might involve the coordination of different decision makers. Okay, so who gets to make these decisions? Well, people make decisions for themselves. Adults make decisions for themselves if they are mentally capable. And we're going to talk about what the law understands mental capacity to be. If somebody lacks the capacity to make a certain decision, then somebody called a substitute decision maker will make that decision for them. Now, a substitute decision maker can be a few different things. And today we're talking about powers of attorney specifically, but there are people, they're called attorneys, who are appointed through a power of attorney document. That's the kind of substitute decision maker we're mostly going to be talking about today. There's other kinds of substitute decision makers. Sometimes they're appointed by the courts and they're called court-appointed guardians. Sometimes there's a substitute decision maker that can happen through a process that's set out in the Substitute Decisions Act called a statutory guardian. That's a different kind of substitute decision maker. And sometimes there is a decision maker that's appointed by this administrative body called the Consent and Capacity Board. And that type of decision maker is called a Consent and Capacity Board appointed representative. Whew, there's not a test at the end, but I just want to give you an idea that a substitute decision maker is an umbrella category, and there's different kinds of legal decision makers that are housed underneath that umbrella. Powers of attorney are one of probably the most common way that people are given substitute decision-making authority. So that's why we're talking about it today. So we said that mentally capable people get to make their own decisions. So how do we know whether or not somebody is mentally capable? There's a few really important details to pay attention to here. Capacity is context specific. So people can have capacity to make some kinds of decisions and lack the capacity to make other kinds of decisions. And the law presumes that adults are capable. So our baseline starting point is to assume that I'm capable, that Amy's capable, that we're all capable of making our own decisions about property and personal care. So point number one, let's see here. So capacity is related to a particular decision. I can give you an example here. So we talked about the two main kinds of decisions that we make, property and healthcare decisions. Something that we'll see fairly often in the healthcare and personal care realm is you may know somebody who, for example, has a long-time chronic illness that they've managed, let's say diabetes. So somebody is diagnosed with diabetes in their 40s, and they've been managing diabetes for, let's say, 30 years. And when they get into their 70s, they're very, very experienced at managing their medication and monitoring their blood sugars and just generally taking care of all the things that come with managing diabetes. And in their 70s, perhaps they're diagnosed with dementia. And there are some ways that their capacity begins to change. Maybe they start becoming forgetful, or certain kinds of decision-making just become more of a struggle for them. That person who has a relatively new diagnosis of dementia may remain capable of managing their diabetes for a long, long time, well into their time living with dementia, because they may live with dementia for 15 or 20 years. They might live into their 90s. And it could be because they have such a clear routine around managing their diabetes that even as their dementia becomes progresses, they're still able on their own to make all of their decisions about diabetes. It could be that at some point while they're managing well with diabetes medication, that they get a diagnosis for a new health condition, let's say a heart condition. They might at that point not have the capacity to understand a new complicated health condition because of the way that their dementia has progressed. So there's an example of a person who could have the capacity to make some healthcare related decisions and not other healthcare related decisions. And so it's important to remember that we don't paint people with a really broad brush, and that we allow people to continue to exercise their own decision making as much as possible. And that means that they might need support for making some kinds of decisions, but they're totally fine making other decisions all on their own. So at law, we look at capacity very broadly speaking, like it can be assessed in lots of different ways, but generally we're looking at an ability to understand and appreciate. So that means an ability to understand information that's relevant to making a decision. So when we go back to that healthcare example, like what information does a person need in order to make a good decision about whether or not to pursue a particular course of medication? Can they understand all of that information? Can they understand that there's different medication options, that perhaps a surgery is necessary? What are the side effects of taking or not taking that medication? So can they understand all of that? And then I kind of jumped ahead here, but can they appreciate what will happen if they make a decision or don't make a decision about something? So can somebody understand like what might happen to me if I pursue this new course of medication? And what might happen if I don't pursue that course of medication? We'll get a little bit more into this when we get into the healthcare section specifically, but I'd just like you to think generally about the idea of understanding information and appreciating the consequences of making a decision. Another thing to remember is that there's lots of people who can understand and appreciate certain types of decision making, which would likely mean that they have the mental capacity to make that decision. And they might make a decision that's really different than the decision that you would make. So people can make capable decisions that are perhaps a little unusual, not the kind of decision that most people would make. And that doesn't necessarily mean that that decision lacks, or that decision maker lacks the capacity to make their own decisions. So it can be hard sometimes to not impose our own values when we're trying to figure out whether or not somebody's capable of making a decision. But it's not about whether you agree with the decision necessarily. Okay, so capacity is not about a score on a test. There's all kinds of tests that exist out there. There's the MOCA test, there's the RIE test, there's different cognition tests that family doctors will perform. These can have very important applications, but they're not determinative necessarily of whether or not somebody is capable of making a certain type of decision. It's also not a diagnosis. I know people who have dementia who remain capable of making all of their own decisions at this point. They make all of their decisions about the management of their property. They make all of their own decisions about their healthcare and other personal care decisions. So just because somebody has Alzheimer's, it doesn't mean that they're incapable of making decisions. Another thing to remember is that capacity can fluctuate. So some of you might be familiar with the term sundowners. So there's some people who live with, for example, dementia, whose capacity tends to drop off as the day continues. So maybe when they wake up in the morning, they're actually feeling quite sharp. They're able to speak with ease. They don't have a lot of memory recall trouble. And as the day goes on, things get foggier and decisions get harder to make. So it could be that somebody who's living with sundowners syndrome, I'm not a doctor, but I've heard this term used, would be capable of making decisions, maybe with some support, earlier in the day. So maybe it makes sense to make sure that any medical exams that have to happen earlier in the day when that person has a better chance of being able to meaningfully make their own decisions or at least contribute in the decision-making process. And so who gets to decide whether or not somebody is capable of making a decision? This can be a point of contention. So it's important to know that depending on the situation, different people are in charge of this process. So as a lawyer, this is kind of a side issue, but I need to make sure if I'm helping a client that they have the capacity to give me instructions. So I need to make sure that my clients can understand and appreciate the instructions that they're giving me. So if they want to sue somebody, for example, I need to make sure, I need to satisfy myself as a professional that this person is mentally capable of doing that. And that is something that I have to do under my rules of professional conduct. It's also an ethical issue. So I think about capacity a lot in my work because I work with older folks, some of whom are experiencing capacity changes. You may have also heard the term capacity assessor before. Capacity assessor is a specific designation. Different kinds of regulated health professionals can become capacity assessors if they go through a certain type of training. And an office called the Office of the Public Guardian and Trustee keeps a list of designated capacity assessors in the province. They can be hired for a fee to conduct capacity assessments in certain situations. And we'll talk about when those situations come up. There's also people called evaluators. This is a term that comes from the Healthcare Consent Act. Evaluators are certain types of health practitioners who specifically make decisions about whether or not somebody's capable of deciding if they're moving to long-term care. So sometimes there's people who move to long-term care who are perfectly able to decide for themselves that they do or don't want to go. Sometimes that decision has to go to a substitute decision maker, and it's a capacity evaluator who decides whether or not the prospective long-term care resident makes the decision themselves or if it has to go to an SDM. Healthcare professionals have to decide every time they're proposing treatment for a patient whether the patient has the capacity to consent or to make a specific treatment decision in that situation. So like I talked about before with the diabetes example, A healthcare provider may know that their patient can make certain types of decisions and can't make other types of decisions. So there might be a substitute decision maker who is helping in some circumstances, but not all of the circumstances. This can get kind of complicated. And like I said, nobody's expected to have this all memorized after today. I'm just trying to paint a picture of all the different ways that capacity and decision-making informs the law of powers of attorney, which is where we're going to jump now. So like I said, property decisions, who makes decisions about property if somebody is incapable? So if you're mentally capable, you can choose who you would like to have manage your property in the event that you one day become incapable. So powers of attorney can be an advanced planning tool. That's the whole point. So you prepare them while you're capable, imagining a possibility that sometime down the road you might lack capacity to manage your own property. That's when people will sometimes choose to make a document called a continuing power of attorney for property. So I keep talking about the document called the continuing power of attorney for property because there's kind of this funny convention where we often refer to a person as a power of attorney. We'd say, oh, my spouse is my power of attorney for property. Your spouse is probably not a piece of paper. A piece of paper is what a power of attorney is. What it does is it appoints somebody called an attorney for property, who will then be the decision maker. I don't know who came up with this scheme. It's confusing because we often think of attorneys as another word for lawyer. It's a common word for lawyer in the United States. But when you hear the term attorney in Ontario, it's referring to the person who's appointed through a power of attorney document. So a power of attorney document requires that the grantor, and that's the word that's used in the Substitute Decisions Act, the grantor is the person who wants to choose a substitute decision maker. So that grantor has to sign the document themselves. Nobody can sign it on their behalf. You can't have anybody sign a power of attorney document except the grantor themselves if you want that power of attorney document to be valid. So the grantor signs it, and there have to be two witnesses, and the two witnesses also have to sign this piece of paper in front of each other. And the person, the grantor, who's appointing the attorney has to be mentally capable of preparing a continuing power of attorney for property at the time that they're making it. And we'll talk about what capacity means in this specific context. Now, in a power of attorney document, the grantor can appoint one or more attorneys. So you can choose one person who you want to make all of your decisions for you. You can choose two people. You could choose four. That would probably get pretty complicated, but you could do it. A power of attorney document also has to be made voluntarily in order for it to be valid. So if somebody feels like they were forced to make a power of attorney document, that somebody pressured them into signing it, it's possible that at some time down the road, through different legal processes we won't go into today, it could be held that that power of attorney document is not valid because it wasn't made voluntarily. This is a key piece that a lot of folks don't know about. Usually, the powers of attorney documents that we see at our office, usually they come into effect immediately because a continuing power of attorney for property document will come into effect on signature unless there's some kind of triggering language in it that says it's not going to come into effect until sometime down the road. For example, if in the future the individual is assessed by a designated capacity assessor and the assessor finds them incapable, then the power of attorney would come into force and effect. But a lot of power of attorney documents don't include that kind of triggering language, which means that as soon as the grantor signs their signature and the witnesses sign it, then the person or people that they appointed have all of the authority of a attorney for property. And we're going to get in about 2 slides to what that authority includes. But before we get there, I just wanted to touch on what capacity to make a power of attorney document looks like. We talked about the understand and appreciate test, which has some general applications, but this is a specific 7-part test that exists under the Substitute Decisions Act, which is the law in Ontario that governs how powers of attorney work. So in order for somebody to be considered capable of making a continuing power of attorney for property document, they would have to meet all 7 of these parts in the test. So they have to know how much property they have and its approximate value, including real estate, investment portfolios, sources of income. They have to know if they have any dependents, like a dependent spouse or children. They have to understand and they have to know what an attorney is actually able to do, which we're going to get to. They have to know that an attorney has a duty to account. So that means that an attorney has to provide the grantor with records that show what they have done in their role as an attorney for property. They have to understand that if they choose, they can revoke the power of attorney. That means cancel it, get rid of it. They have to understand that continuing power of attorney document confers really significant authority on somebody. And there's a real risk that the person that they appoint could mismanage their property or could financially abuse them. So somebody needs to understand all of this stuff in order to be considered capable of making a power of attorney document. So if somebody has advanced dementia, not that dementia means that they can't make a power of attorney, but let's say it's quite advanced and they don't meet all of the requirements on this list, then any power of attorney document that they try to make would likely be invalid. What can an attorney for property do? And I should interrupt myself briefly here. I've used the word continuing power of attorney for property. It's called that at law because it continues to be in force and effect even after somebody loses the capacity to manage their own property. So we often just talk about powers of attorney for property, but technically it's a continuing power of attorney for property that somebody can make while they're capable and can continue along even if they lose capacity sometime after they've made it. So this is where the rubber hits the road in terms of seriousness. An attorney for property or a guardian, which is that kind of substitute decision maker that the court can appoint, they have legal authority to do anything with somebody's property that that person can do themselves, except make a new power of attorney, revoke a power of attorney, or make a will. That's really serious. So basically, an attorney for property can step in and sign documents on behalf of the person who appoints them. So think of all the things that you can do with your signature. You can buy a house, you can sell a house, you can mortgage a house, you can open a bank account, you can empty a bank account, you can close a bank account. These are really significant powers that are given through what is sometimes a document that people take about 5 minutes looking at and signing. So I always urge people to think really carefully about how serious this authority is. Now, a continuing power of attorney document can have restrictions in it. The generic ones that you see tend not to have restrictions in them, but you could, for example, write terms into a power of attorney document that says the person that you're appointing couldn't buy or sell property in your name or couldn't refinance your house, for example. But you don't see those restrictions very often. All this to say, if you are choosing somebody to appoint as your attorney for property, or if you have been appointed somebody's attorney for property, it's a really big responsibility. And you need to think really, really carefully as the grantor about whether this is somebody that you trust and you think you will be able to continue to trust. And so we spoke before how you can appoint one or more people as your attorney. If you appoint multiple people, they can either be appointed jointly, which means they're only allowed to make decisions together. Some people do that because they want to sort of check and balance to make sure that there's two people who are checking in with one another who can't just go off and do something. So sometimes people will, for example, appoint their spouse and then also an adult child, and then those people will be responsible for making the decisions together. You can also appoint multiple people jointly and severally, which means that either one of them can make a decision independently, or they could make a decision together. There's times where that's a practical option. It may not have as much of a check and balance in place, but it can really depend on family or community dynamics, who it is that's helping or maybe helping in the future as a substitute decision maker. We see a lot of cases at our office. Like, I have to remind myself that as lawyers, we often spend a lot of times in the murky depths of where everything goes wrong. A lot of the times things don't go wrong, and powers of attorney are prepared and it works out relatively well. There are a lot of situations, unfortunately, though, where somebody who's been appointed as an attorney for property misuses the authority that's been given to them. And that can mean, for example, emptying somebody's bank account without the permission, or with like stealing. Attorneys sometimes steal, refinancing a home, potentially selling somebody's treasured belongings without that being necessary or a good idea. So there's lots of ways that an attorney can mismanage property. And if that happens, there's a few options. So if the person is still capable, it might be that they didn't even know that the other person or that the attorney that they appointed was already acting as the attorney for property, because they didn't realize that when they signed that paper, it went into effect right away. So I've definitely had clients before who've come to me and said, I signed this document, but I thought it was going to be, in 15 years when I maybe needed help, but I've found out that my son's been dipping into my bank account. In that example, if the individual is still capable of making or revoking a POA, they can revoke the power of attorney. They might choose to prepare a new one, but maybe they don't have anybody else they'd like to appoint. They would have to meet that 7-step capacity test. They can also ask that their attorney account for everything that they've done with the grantor's property. So that would require providing a written accounting of all of the transactions that have happened on that person's behalf. And like I mentioned, they may also choose to prepare a new power of attorney for property. There's actually a criminal code offense called theft by power of attorney for property. So somebody can actually be criminally charged if they steal from somebody who's appointed them as their attorney for property. In my experience, it's a very underused criminal code provision. So I don't know of that many cases where people have actually been charged with it, but it would be a very serious charge if it did happen. Unfortunately, like I mentioned at the beginning, it can be really hard to try to piece things back together after something has already gone wrong, because if it's money that was stolen, it may be long gone and impossible to recover. It can also cause a really, really difficult and sad family strain, challenging dynamic issues if the grantor appointed somebody in their family and then that person stole from them. So there's a whole complicated layer there. All this to say, better to think about it ahead of time so you don't have to get to the point where you're dealing with somebody having abused their authority as an attorney. So I link at the end a kit that you can use to prepare your own power of attorney document, and I link it with caution. And I hope that you understand why, based on what I've told you so far, because this is not the kind of document that can be made or should be made lightly. My boss, the executive director at our clinic, goes so far to say as people should think as carefully about who they appoint as their attorney as they do about who they will marry, because the significance of the legal relationship that is created through the preparation of a power of attorney document can't really be overstated. So you got to make sure it's somebody that you trust. Some local community legal clinics assist with the preparation of power of attorney documents. Unfortunately, our office typically does not. We do lots of public legal education about it, but we just don't have the people power to make all of the power of attorney documents that people would like us to. A lot of folks go to private bar lawyers, so they pay a lawyer to help them make a power of attorney, and that often happens at the same time that people prepare a will, but you don't have to make them at the same time. Okay, so who can assess whether or not you meet that 7-step test? Usually it's like a collaborative process that happens with the people who are there while it's being made. It doesn't have to be made in a law office. There doesn't have to be a capacity assessor. There are some situations where it makes sense for there to be a capacity assessor. For example, sometimes a lawyer will require that somebody hire a capacity assessor to specifically assess their capacity to make a power of attorney document, because the lawyer is not confident about whether or not that person passes that 7-step test. And they want to make sure that nobody has a good reason to challenge the power of attorney document somewhere down the line. So the capacity assessment can be kind of like an insurance to make sure that the power of attorney document will be valid and subsisting. Okay, what happens if you don't have a power of attorney document? So I mentioned there's something called statutory guardians. I don't have time to go into the whole process about how those are made, but they do require a formal assessment by a designated capacity assessor. And there's a link in materials at the end from the Office of the Public Guardian and Trustee that sets out how the statutory guardianship process works. Sometimes, though much more rarely, the courts become involved and appoint a guardian of property for somebody. And then there are narrow situations where there's trustees that can assist with the management of people's property for the purposes of managing different kinds of social assistance. So sometimes there's folks who, for example, are on the Ontario Disability Support Program who use the trusteeship program that's available through ODSP because they lack the capacity to manage their own property, but they didn't prepare a power of attorney document, or they don't have anybody that they can trust to do that, and they don't have any other assets that would need to be managed anyway, so it gets managed by a trustee at ODSP. Very briefly, sometimes some of you may have encountered this, banks, it happens less now, but banks will sort of hand people power of attorney documents and say, well, you have to use our standard form power of attorney document. We won't accept that one that you made at the lawyer's office. Banks aren't supposed to do that. They're supposed to accept validly prepared powers of attorney documents. Sometimes they have good reasons to be concerned about documents that might be presented to them, like maybe if it's a really blurry copy or they're noticing a really weird dynamic between two people who've come into the bank together. But I'm just raising it as a flag that sometimes banks will say, oh no, you have to fill out this one. That's not something that you want to do without thinking very carefully about it and probably getting legal advice, because if you fill out the banking document, you might invalidate another good power of attorney document that you've already made. And there may be some weird terms in that banking POA that you don't actually want to get into. So raising it as a flag, seek legal advice if you encounter one of these. As I have a tendency to do, I've just been chatting and chatting away here. So I'm going to try to get through personal care decision-making in 15, 20 minutes. So we have a good chunk of time at the end for answering what I hope are some really interesting questions on your part. So I've given you the very high level decision-making for property, continuing powers of attorney for property 101 course. Now I'm going to do the same for personal care decisions, because as you'll remember, we have these two categories of decision making. Okay, so how do you plan for incapacity for personal care decisions? There's different ways. Lots of people don't plan at all, and we'll talk about what might happen if you haven't done any planning, and there's decisions that have to be made on your behalf and you're not capable of making them anymore. But let's assume somebody has the capacity, which we'll talk about, to plan for their own potential incapacity down the road. So if somebody's mentally capable, they can choose who they want to have making their health and personal care decisions down the road if they need help. And that can be done by signing a different kind of power of attorney document called a power of attorney for personal care. If an individual is capable, then they make their own decisions. So much like a power of attorney for property, which we've already reviewed, a power of attorney for personal care is a document in writing in which you name a person or people to be the attorney, this time an attorney for personal care. So some people will appoint one family member as their attorney for property and a different family member as their attorney for personal care, or multiple family members in each category. There's no rule that says that the same person has to fill both roles. And in lots of situations, it makes sense to appoint somebody different depending on their skill set or how much time they have. There could be a family member who's an excellent attorney for personal care, who's maybe not great at managing money, so wouldn't make a good attorney for property. And that's okay. It makes sense to think carefully about who might do this role best. In a power of attorney for personal care, you can make note of, though you're not required to, certain wishes about health care and treatment. So this is like an imagining exercise where people go, okay, if some point down the road, I'm no longer able to live in my house, what would I do? And they might say, I wouldn't want to go to a long-term care home. I'd rather go to a retirement home. Or they may have a retirement home chosen that they would like to go to, and they might write that down. Or they might say, perhaps it's somebody who's lived with cancer for a really long time, and they know that they don't want to go through chemotherapy for a third time. They might put in their power of attorney document, for example, that they wouldn't want to do intensive chemotherapy for a third time if they became incapable of making that decision about chemotherapy themselves. Now, I'll talk about this more in a little bit, but it's important to flag that just because somebody writes something in a power of attorney document, it does not mean that that's what the doctors look at and what the doctors have to follow. The doctors have to make sure that they get what's known as informed consent at the time that the treatment is being proposed. Because somebody might say, for example, I'm not going to want chemotherapy for a third time. But if that decision came up sometime down the line, maybe the chemotherapy treatment has really changed and it wouldn't actually be that invasive for this particular type of cancer. And you wouldn't want to go back at this piece of paper and say, well, back when they were capable, they said no more chemotherapy, because that was a really abstract wish. And when you put it in context, it might be a very different decision to make. Like continuing powers of attorney for property, there must be two witnesses who witness the grantor preparing the document and who sign it themselves. Okay, unlike a power of attorney for property, which we've come to know that in most cases is effective on signature, a power of attorney for personal care only comes into effect when somebody is incapable of making their own personal care decisions. And the person who decides whether or not somebody lacks that capacity is going to depend on what specific type of personal care decision is being made. So if it's a treatment decision, it would be the health practitioner who's proposing it. But if it's for other kinds of personal care decisions, it will usually be the attorney for personal care themselves, unless there's a specific provision in the document that says, for example, there would have to be a capacity assessment to decide whether or not somebody makes their own decisions around, let's say, shelter or nutrition. That might sound a little bit complicated, so I'm happy to take questions about that if you've got them. Okay, so we had a 7-part test to make a power of attorney for property. It's not a 7-part test for power of attorney for personal care. It's whether or not the grantor has the ability to understand whether the proposed attorney, let's say their best friend or their adult child, has a genuine concern for the grantor's welfare, And they have to be able to appreciate that this person they're appointing, or the people that they are appointing, is going to potentially have the authority to make really significant decisions for them. Okay, so like I said before, there's a link at the end to the free power of attorney kits. And for reasons that will become clear, I'm issuing a big caution around using them. They're not bad, but they need to be created really, really thoughtfully, because like with a power of attorney for property, somebody who holds a power of attorney for personal care has a lot of really significant decision-making authority. So same too with powers of attorney for property. Your local community legal clinic, there's actually a couple in Scarborough. I think at least one of them does assist in some cases with the preparation of power of attorney documents. It's always a good idea to get legal help that's specific to your situation. Okay, you need to make sure, if you decide you want to prepare a power of attorney document, that you pick somebody you trust, because if you are found incapable of making some sort of personal care decision, and again, you might be capable of some and incapable of others, this person's going to potentially be able to make decisions about where you live, what healthcare you will or you won't get, what food you're going to eat, what clothes that you wear, what kind of risks that you can take. Big, important life decisions, really foundational stuff. And like with attorneys for property, a power of attorney for personal care, if there's more than one of them, they can either act jointly, which means they make all their decisions together, or jointly and severally, which means that they could make decisions by themselves or together. Okay, so what if somebody hasn't made a power of attorney for personal care? Who would make decisions for them in that case if they lack the capacity to make a particular type of decision? So an important thing to know is the law called the Healthcare Consent Act sets out a hierarchy of substitute decision makers that everybody has, regardless of whether or not they've prepared a power of attorney document. So when we were talking about property, there's no automatic list of substitute decision makers for property decisions. When we move over to this category of personal and healthcare decisions, there are, in some types of decisions, automatically for everybody, even if you've never thought about substitute decision making before, you have a substitute decision maker. There's also some instances, like with property, where people can bring an application to the court and the court might appoint a substitute decision maker, even if a power of attorney document was never made. So the next slide is a list of substitute decision makers set out under Section 20 of the Healthcare Consent Act. And anytime an incapable person, or anytime a treatment needs to be made on behalf of an incapable person, and in this case, that incapacity has been assessed by the healthcare provider who's proposing a treatment, we have to turn to the Healthcare Consent Act. The doctor, usually it's a doctor, has to turn to the Healthcare Consent Act and find the highest person on this list. So the ultimate trump card is a court-ordered guardian of the person. So sometimes, even if somebody prepared a power of attorney document, for various reasons, there might be a court decision at some point that appoints somebody different to be the personal care substitute decision maker for an individual. So number one, ordered by the court. Well, that's just the highest. Next is an attorney appointed through a power of attorney for personal care. So that again can be one or more people. I spoke briefly earlier in the presentation about representatives under the Consent and Capacity Board. They're third on this hierarchy. Then it goes through a list of relatives. So first decision maker, if there's nobody in one of the first three categories, would be an individual's spouse if they have one. And spouse is broadly defined. They don't have to be legally married. It can include common law spouses as well. Then it would be child or parent. Then parents who only have access rights are ranked lower than parents who have full access. Then it will go to brothers or sisters, then any other relative, that could include aunts and uncles, cousins, second cousins. And then finally, if an individual doesn't have anybody in any of the first 8 categories, then the Public Guardian and Trustee's Office has a treatment decisions unit where there are individuals or where there's a team that can make decisions on behalf of incapable individuals about whether or not a proposed treatment will go ahead. Okay, so you can't just fall into one of those categories. You have to fall into one of those categories, be the highest on the list, and be capable yourself. So you won't be somebody's substitute decision maker if you yourself are incapable. You have to be at least 16 unless you're the parent of the individual who needs to have a decision made on their behalf. There needs to be no court orders or prohibitions around contact between the incapable individual and the prospective substitute decision maker. They have to be available, and significantly, they have to be willing to act as substitute decision maker. So I'm going to flip back. Let's say an individual is single, they don't have a spouse, and they have one child, no living parents. That child might be unavailable. Let's say they live halfway around the world, they have a really busy job. Anytime the doctor calls them, they're not available by telephone. Or that child is estranged from their parent and for whatever reason does not want to be involved in the decision making, then you would have to go down the list. So even though somebody exists in a category, it doesn't mean that they will be the substitute decision maker. It's true too for powers of attorney in general, that the person who has been appointed as attorney has to be willing to act in that role. So just because you've been appointed by somebody doesn't mean that you are obligated to take that role on. You can resign as an attorney, which is a process that can happen in writing, or you can just simply say that you're unwilling to act. It's not a mandatory requirement that somebody act as somebody's attorney for property or personal care. Okay, if there's more than one person in a category, and lots of those categories could have multiple people in them, then they have to act jointly, not jointly and severally. So that means that they all have to agree about what the healthcare treatment decision is going to be. And if they can't decide, and this happens sometimes, then the decision ends up going to the Public Guardian and Trustee Treatment Decision Unit, who makes the decision in the case of a stalemate where equally ranked decision makers simply can't agree about what to do. So we don't have time to go too deep here, but generally speaking, a substitute decision maker for healthcare, if they are aware of the wishes of the person that were made when that person was still capable. So potentially you've been appointed as the attorney for property for your mother, and you and your mother maybe had some really great conversations before she lost her capacity to make her own healthcare decisions about what she might like to happen as her health changes and as she grows older. That's really helpful information to have because it can help you guide your decision making when you are stepping into the role of substitute decision making and you have to make really important decisions on an incapable person's behalf. Lots of the time, people don't talk about what their wishes are. And by the time they lack the capacity to make a certain decision, nobody really knows what their wishes would have been. Often people will have an idea, even if they didn't talk about it explicitly, if they know the individual really well and knew them really well before they lost the capacity. But if you don't have a sense of what somebody's wishes are, then you have to act in their best interests. And the the Healthcare Consent Act is really detailed about what best interests are. So you have to take into account the values and beliefs. Sorry, I said the Healthcare Consent Act. It's actually both laws make reference to best wishes. What treatment's being proposed, and is it going to make the person's life better or more comfortable? Are there benefits that outweigh risks? Is a treatment that's being proposed super, super risky and probably not the kind of decision that that person would have made for themselves? Like, thinking about best interests is a complex process, and best interests will depend on the person. It will depend on their health circumstances and the treatments that are being proposed. So as a substitute decision maker, and today we're talking about substitute decision makers who got that authority through a power of attorney document. But as we know, there's other ways that somebody might become a healthcare treatment substitute decision maker. The job is broadly to interpret what that patient would have decided if they could have capably decided for themselves. And there's a list here that you're welcome to peruse afterwards. So I'll briefly touch on this idea of advanced care planning. We hear about this sometimes, and sometimes that portion of a power of attorney for personal care document where people can set out details of how they might like things to go if they lose the capacity down the road to decide for themselves. Like, that's an opportunity for people to express their wishes. But as I've mentioned before, wishes like this are not legally binding. They're really about helping to inform the future decision makers how they might be able to act in the best interests of the person who appointed them. And nobody actually needs to set out their wishes. And you don't have to sign any kind of do not resuscitate or living will or advance directive. Sometimes people are provided documents that have these different names. They're not required. Nobody has to fill them out. And a substitute decision maker for healthcare and personal care decisions can do a good job acting in the absence of these kinds of documents. So we talk about them often at our work because they can kind of muddy the waters sometimes around what's required of people who are planning for their possible incapacity. You don't actually have to sign any kind of advanced directive. Sometimes people are given them if they move to a retirement home, for example. If you don't want to sign it, you don't have to sign it. As I said, wishes, they can just be a conversation that happens between family members, happens between somebody who may lose capacity in the future and the people that they've chosen to be their substitute decision makers. They could write down their wishes. They may record a video of themselves speaking their wishes and then provide that video to their caregiver or to the person that they've appointed as a substitute decision maker. And this is just sort of another summary about what I've been saying here. All right. So with both types of powers of attorney, I really want to hammer home the point that the only person who can make it is the person about whom decisions might be made at some time down the road. So I can't make a power of attorney document for my parents, even if I think it's a really good idea that they have it in place, even if I'm suggesting that we appoint somebody other than me in the role of substitute decision maker. I just can't do it. The only person who can is the individual who is named as the grantor in the document. Now, this is a lot of information that I've dumped on you. I see that it's 2:06 and this is a 90-minute presentation. And so that leaves us about 25 minutes. I can talk about more stuff, but I think I might like to open it up to questions shortly. Let me just scroll through here. We're going to get to our question section. Obviously, big thank you for having me. This is really great to speak with you about. And the last slide, again, I'll be sharing this PowerPoint so you can look at it. But this last slide here has a link to our website. There's 2 pamphlets from Community Legal Education Ontario, which is a great part of the legal clinic system that prepares plain language legal resources. And they have a booklet about continuing powers of attorney for property and a booklet about powers of attorney for personal care. They're really user-friendly. There's digital copies, but you can also request paper copies directly from Clio. I really encourage you to take a look at that. Here's these the power of attorney kits that I've referred to. They can be really helpful to look at just so you have an idea about what a power of attorney document looks like. I'm realizing now I should have actually just put one up on the screen so you could see one. I'm sorry I didn't do that. And then there's some general information from the Office of the Public Guardian and Trustee, which include the information around the court appointment of guardians, which I referenced. I also referenced something called statutory guardians. It'll also take you to links about capacity assessors. So there's some good general information there that may be able to fill in some gaps of details we weren't able to cover today. So without further ado, I might pass it over to Amy, who will explain how this question section is going to go.
And thank you for that. I just want to say thank you. And your slide, turning that thank you back to you. That was a lot of information, but so important. And as was mentioned, I will be sending out the follow-up information. And specifically on the topic of advanced care planning, we did have an advanced care planning presentation earlier in the summer, and I will send along the recording for that because it is, as we did a session on it, it's worth a conversation and worth diving in.